Being 9:02, I call to order the January 27, 2026 Special Magistrate hearing for the Daytona Beach rental program. I'm just going to go down the list on our agenda. Are there any announcements?
There are no announcements.
No announcements. Okay. I have approved the October 28, 2025 minutes, and that is taken care of. We now move on to the hearing of cases, and a few things before we proceed with that. First of all, the procedure is fairly simple. I will call a case, and if at that time whoever is here as a representative or as the owner of that property could come forward to the lectern that is over on your right side. The city inspector will be at the lectern over on your, or whatever, over here. And at that time, you will need to be sworn in. Because you will be giving testimony under oath. And the way the process works is the city inspector will state the case and the reasons for why the city has cited you. And the city attorney may have some things to add as well. When they finish, you will be given an opportunity to respond, and there may be some further back and forth that takes place after that. The idea is to try to put everything that in the record that the city considers relevant, and the things that you may want to put in the record should there be a need for any further proceedings. All right. I have approved the minutes of the last meeting. And at this point, we need to swear in anyone who was with the city who will be giving testimony today.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Okay, now we'll start with the cases. There's only 5 of them today, so this should go fairly quickly. Our first 2 are on Zoom. Case number 1, and by the way, there are people sitting behind that barrier. Are you all ready to today?
Yes, sir. We're ready to go.
Okay. Case number 1, RTL 012603, Woolfolk Detress Victoria K. Trust and Woolfolk Legacy Revocable Trust, cite for failure to correct violations of Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.a.2 at 152 Kingston Avenue. Okay?
All right. Can you state your name for me?
My name is Detrice Woolfolk.
Okay. Can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Yates?
The daily posted rate was $96, and it
Hey, I'm so sorry, Your Honor. Okay. Can Inspector Yates start that over? We had a technical mishap back here.
absolutely. All right. The case before you was a zoning violation. This case was field generated. The property is zoned MFR 20. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed November 6, 2025, and they were notified the same day. The property stopped actively advertising as of November 14, 2025. The daily posted rate was $96. The advertisement displayed 1 review. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Anything further?
No, Your Honor.
Okay. Ms. Diaz, do you have anything that you wish to add?
Are you talking to me?
I'm talking to Ms. Diaz, who's the assistant city attorney. She's, I think, going to make some statements.
Good morning, everyone. The city's position is that the beneficial gain to the property owner who is advertising conduct that is prohibited by city code is unlawful and pursuant to Florida statute 162.091D is irreparable and irreversible. Under city code section 90-298, advertising alone on a platform such as Airbnb, Vrbo, alone creates a presumption of liability. In addition, Florida statute section 509.013 subsection 4A1 defines transient public lodging establishment to include any dwelling that is advertised or held out to the public as being rented to guests for less than 30 days or 1 month. Advertising the property in this manner violates city prohibition on short-term rentals. The city and those unlawful bookings that take place are to the detriment of the patrons by steering them into unregulated accommodations while simultaneously harming licensed hotels, motels, and lawful vacation rentals that comply with zoning, inspection, insurance, taxation, and staffing requirements. Especially the staffing requirement of having people on site 24/7 to address any concerns that the community or the patrons may have. This happened after This was an outcry to our city commission after residential neighborhoods were taken over by Airbnb guests. I think it was one of those trucking events where they were playing music at all hours, disrupting the neighborhood, and there was no one on site to curb this behavior, and there's no one on site to address any of the concerns the community may have when guests act out of line in this way. In addition, the City Land Development Code prohibits this type of short-term rental use. I'll spare you the long citation. Other accommodations under our Land Development Code include vacation rentals and transient lodging, which are not permitted in the zoning districts for these cases. Section 111.5 defines other accommodations as dwellings, units in rented or leases to transient people or tourists for less than 6 months. This definition explicitly excludes motels, hotels, or bed and breakfasts, but continue to regulate short-term rental lodging recognized under a prior city code. These violations directly harm the community. These enforcement methods that we're taking today arise from a clear and sustained demand from the community to curb this behavior. By the time the city intervenes, the unlawful profits have already been realized as a result of meaningful fines are the only effective deterrent available to the city. Accordingly, the city requests the finding that these violations are irreparable and irreversible in nature, and that given their gravity, a fine of up to $15,000 is warranted.
Ma'am, it's your turn now, if you have anything to say in your behalf.
Yes, sir. Thank you, everyone. So pretty much, I did not know. I was unaware of the whole, other accommodations inside. And once we found out, we definitely stopped everything. The site wasn't up no past 30 days. We just started. The house was under construction due to a lawsuit that I was going through with the seller because they did some illegal things that the city, I think they didn't get proper permits when selling the house to me. So I had to go through my own, legalness with them for months, which kind of put me into a financial state because I wasn't able to pay the mortgage. And then, my mortgage was going to get taken. So I was trying to find a way to, help with that, situation because there wasn't no grants for me, no other type of, like Volusia County didn't have any help for me to make sure that I did not lose my house. So I was just trying my best to find a way to still live in my house, and make a little bit of money on the side to help me with the mortgage because I'm already in $35,000 in debt right now due to the house being sit dormant because it was deemed unsafe. For a whole year by the city from my insurance company. So I wasn't living inside my house for a whole year, and that meant I couldn't pay my mortgage. So I did not mean any harm by doing this. I was just trying to, help myself, as a person with my first home to try to help, get the mortgage back down and payments. So I definitely do sincerely apologize, not knowing. But I did once I seen the paperwork, I did shut it down. And within the time that it was up for those few weeks, it was only just one guest that was there, and that was it. We stopped everything. But the only thing I did it was because of financial situation from the seller, not getting the proper permits from Daytona, the city of Daytona, selling a house that was not properly permanent, and I had a falling beam in the house, which could have, God forbid, kill me or somebody that I love in the house by me not knowing and Daytona and the seller not having the proper permits.
Does the city have anything further it wishes to add?
No, Your Honor.
Okay. I hear you and I understand your situation. However, I've been doing this now, I think we've started these about 8 years ago, about 2017 or thereabouts. And one of the things that I try to do is to treat each situation similar situations are dealt with in a similar fashion. And initially, when I started doing this, everybody who came before me, the city was asking for the largest fine available, which is $15,000 under the statute. And there were quite a few of those that were levied. And then as the time wore on, it emerged that there was a difference between those people who were actively engaged in this type of activity and those who did it unwittingly, although you're presumed to have knowledge of the law. That is the law in Florida. Whether you are aware of it or not, if it's on the books, you're supposed to follow it. And so I kept backing down the amount of the fine and eventually backed it down to $1,000. But at some point, it becomes very difficult to distinguish between those people who, there comes a point where I can't go any further without having people who are engaging in this, who might very well be saying that they have reasons, and those who don't. And I like to treat everybody the same way. So I'm going to uphold the city's request for the $1,000 fine. And I just want you to understand that that's probably a whole lot less pain than the $15,000 that had originally been asked for years ago and had been levied against other properties. So therefore, I hereby find the respondent Woolfolk Detress Victoria K. Trust and Woolfolk Legacy Revocable Trust in case number RTL 012603 as the owner of the property at 152 Kingston Avenue to have been in noncompliance of Article 4, Section 4.1a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.09 1D Florida statutes, and the property has subsequently been brought into compliance on November 14th, 2026, or no, 25. And hereby order that the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Question, is there any way I can appeal this or give documentation of everything that has happened to me? Because I feel as though that I can show proof. I got lawyer fees. I got everything because I'm still struggling, not being able to pay my mortgage right now. So is there any way I can appeal this, show documentation from the courts and everything on what's been happening last year?
Two things. First of all, there is an appeal process by statute. It's in chapter, was that 162?
Yes.
But it's a long and involved process. It's costly. And my decisions have been appealed. And there is case law around the state where similar decisions have been appealed. And so far in the circuit courts, they've pretty much all been upheld.
Yeah.
And secondly, and this is probably more on point, this becomes a lien against the property. And unless the city was to choose to go and initiate the process for obtaining that money, which is kind of an involved process, it just sits there for, what is it? The lifespan of one of these is 20 years.
Yes.
Yeah.
So, it's there on the property, but you don't necessarily have to pay it. It does draw interest though while it's sitting there. So
Is
that,
there a payment plan that you all have? Again, I just moved to Daytona a couple of years ago, so is there a payment plan? Because again, I don't have 1,000. I'm still trying to make my mortgage every month. So,
A lien isn't something that you pay now. A lien is something that goes on your property, and then if you were going to sell your house in the sale of your home, it would be paid then. Or if we decide to foreclose on it, which I don't think we'll do for $1,000.
And also, if it's a homestead property, we can't do that.
Yeah. Okay, I didn't know.
so
there's no
So,
immediate obligation, from what I'm hearing, that you have to pay it. It just becomes a lien against the property. Now, a mortgage like you have has a monthly payment that is due every month. This is just something that sits there until such time as you either have the money or you sell the property.
And then, so say for instance, and I'm not trying to hold the courts up, but if I have, say, the money in 2 or 3 years, do I come back and just come to y'all and say, hey, I finally got the $1,000, or how does that work?
It does draw interest. And so that in 2 or 3 years, it may be more than $1,000. It's like your mortgage. If you didn't pay it for a month, it draws interest, and there's, things of that nature. There's also a lien review process. At some point, you might be able to come back and say, well, these are circumstances that would warrant that, I would like to just pay $1,000 or what have you and skip the interest. I don't know. Those are things that would be considered later on.
Okay, so somebody will contact me with all these details.
No, so you can reach out to your inspector, Mr. Yates, and he can explain it to you, but the appeal's up to you. I'm the counsel for the city. I can't give you legal advice. What I can tell you is that if you go in the statute that I mentioned, it's Florida Statute 162.09. It talks about what gives us the authority to put these fines. Our land development code, the citation for the land development code where you can read is it's 5.2.A.2, and it's a footnote, footnote 1. And then there's also our land development code section 11.5, which defines what other accommodations are. Sorry, I'm giving a lot of citations. And the last one is Florida statute 509.032 subsection 7. So you can, if you're preparing your appeal, an appeal would be based on an argument that you didn't violate these sections. You could go forward with that, or you could also do a lien review, which would be once you come into compliance, meaning you're no longer advertising this.
These
or
can't come
conducting
into
this.
compliance. These are irreparable, irreversible, so they cannot come into compliance, so there is no lien review.
Yep, so then it would just be the appeal under that statute.
But ma'am, as far as looking for these statutes and stuff, if you contact me after the hearing, I can send you an email, and that'll have links to our Muni code and the different places you find those, so it'll be a little easier for you.
And I'll be also providing you with a order once I get it signed by the magistrate.
And that just explains the fine and how to pay it and all that good stuff is what she's talking about.
Is on there, right?
I'm not 100% if
The appeal is by
on there.
statute.
That's by statute.
And I would tell you also that it says that an appeal shall be filed within 30 days of the execution of the order to be appealed. So it's a very short time frame if you choose to go that route.
Okay, thank you all so very much this morning for the information and so forth. And I look forward to the emails, and Mr. Yates, I definitely will contact you this afternoon after everything.
I'll get right
I
with
appreciate
you.
it.
Okay. Thank you.
Thank you.
Okay, case number 2 is also by Zoom. Case number 2, RTL 01-2601, Daniel W. and Kimberly A. Phipps, is cipher failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 500 Silver Beach Avenue. The property is zoned RP, and short-term rentals known as other accommodations are not a permitted use in the zoning district. Do we have someone present?
Yes, hi.
Good morning.
Good morning.
Are you Kimberly Phipps?
Yes, I am.
Okay, if you would be sworn in, and if there's a gentleman behind you, if he is going to be giving testimony, he needs to be sworn in as well.
Okay, it's my husband. He's also the owner of a property.
All right, if you both can state your names for me.
Kimberly Phipps.
Daniel Phipps.
Okay. And raise your right hands. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you.
Okay. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed October 16th, 2025, and they were notified the same day. The property stopped actively advertising as of October 21st, 2025. The daily posted rate was $119. The check-in, check-out time were shown as 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, we're seeking a one-time fine of $1,000.
Okay. Ms. Diaz, do you have anything to add?
Hello, ma'am. Were you guys present via Zoom when I gave my speech on the city's position? Did you guys hear that speech?
No.
No.
I'm sorry.
Great.
I didn't
We
see
were in the waiting room.
It looks strange when it didn't look like you were looking at us. Sorry.
Okay, then I will repeat it for the record then so that you can
Okay.
hear it. Okay. The city's position is that the beneficial gain to the property owner who is advertising conduct that is prohibited by city's code is unlawful and pursuant to Florida statute 162.091D is irreparable and irreversible. Under city code section 90-298, that advertising alone creates a presumption of liability. In addition, Florida statutes 509.013 subsection 4A1 defines transient public establishment to include any dwelling that is advertised or held out to the public as being rented to guests for less than 30 days or 1 month. Advertising the property is in this manner violates city's prohibition on short-term rentals. The city's land development code also prohibits this type of short-term rental use. Under our land development code, section 5.2A2, it's note 1, other accommodations include vacation rentals and transient and lodging, which are not permitted in zoning district. And section 11.5 defines other accommodations as dwelling unit that is rented or leased to transient persons or tourists for less than 6 months. The definition explicitly excludes motels, hotels, or bed and breakfasts that have gone through proper licensing, inspection, taxation. These are the properties that have on-site people to help our public, the community, and the patrons on-site 24/7 of any concerns that may arise. This enforcement mechanism is something that was an outcry from the community to our city commission to enforce, to prohibit this type of behavior. I believe that this started with, I think, one of those city events, might have been a trucking event, I'm not sure, but during one of these events, communities and local and residential neighborhoods were taken over by these Airbnb guests, where they were being loud, unruly, bringing in crime to these residential neighborhoods. And there was not on-site Airbnb host 24/7 to address the concerns of the neighborhood. And when something happens in the patrons during their stay at the Airbnb the Airbnb or Verbo or any other sort of rental property, there's not a host there on site to help them. There's not staff, there's not security, there's not, again, like taxation, there's not licensing, there's not inspection. And this creates a risk that we have to remedy through no other means except through this hearing and just ceasing the behavior. These violations cause direct community harm. Transient use is unauthorized in residential neighborhoods. It impacts the parking, noise, density, and safety, and undermines the peaceful enjoyment residents are entitled to expect. Enforcement is further limited by the transient nature of these rentals, making advertisement the primary and often the underlying violation. By the time the city intervenes, the unlawful profits have already been realized as a result. Accordingly, the city requests a finding that these violations are irreparable and irreversible in nature, and that given the gravity of their given the gravity, a fine of up to $15,000 is warranted under Florida statute.
City have anything further?
No, Your Honor.
Okay. Mr. and Mrs. Phipps, it's now your turn. State your position.
Hi, we put it online because we were told after Hurricane Milton happened, and we have had rentals since then, which is a year and 4 months later, that still have not been rented. So the people next door always rent their places. They are zoned exactly the same. And so we put it up, and it was actually one of their guests' ideas, telling us that we could do so. So we looked at the zoning. They are the same zoned as the same as us, and we put it up. Within not even 12 hours, our tenant told us that there was a cease and desist, and we ceased and desist. And Kevin knows that, you know, we know him, and we've been in direct contact with him, and we told him that it was an honest mistake. And I plead with we are financially strapped because everybody is doing Airbnbs, and because they don't have to have the upfront costs. And we're not going to do it, obviously. And we took it down. We lost $5,000. It was during the bike week. And that's all I mean, it was an honest mistake.
One thing I would like to add, she had mentioned about the impact we had on the area. No guest had arrived at the property. I mean, once we got the cease and desist notice, we notified everybody that was on the book, which was
And it was in February, yeah.
So none of these guests arrived on the property to cause an impact. Now, the property next door to us, they always have a huge footprint of over parking. And I mean, we're right next door to that property.
We own the 3/4 acre next door.
The overflow of parking from that building always takes up the street.
All of our long-term rentals.
They overnight their trailers during bike week are all parked down the street. Our tenants can't park because we have a driveway, and then we also have the side view. But we had no guests show up during that time that could give an impact to any of the residents around us.
Yeah, so thank you for that information. I just want to point out that for our short-term rentals, we have one city employee, and that's Kevin. So if you help, and you can, he bases a lot off of community complaints and what he sees. So it's not that he is singling you guys out. He probably just hasn't gotten to that yet. You know, if now that he knows, I'm sure he'll investigate it. But that doesn't absolve you of your. Let me finish.
No, I'm sorry to interrupt you. No, I mean, we did it.
It was an honest mistake.
An honest mistake. I mean, it's not going to happen again. We're going to stay with the 6 months or year leases, which we've done for years. I mean, this property has been in our family since 1948, I think it was. So we've always had it in our family, and it's always been a rental. The house next door, we also own, which is 506.
506 and 500, the whole 3 acre, 3/4 of an acre.
That was actually my grandmother's property. She purchased that. I think it was 1950 or 1948, something like that. So she built the apartments in 1955. So the property's always been in our family, so it's
This
something
was
that-
the only one time that we were told by a guest staying next door
Like, oh,
that,
yeah.
oh yeah, you'll bank.
Yes.
Everyone banks.
So unfortunately, that guest isn't an attorney or a city employee.
No, I know,
but
yeah.
Let me finish.
We're just
So-
asking to be, to understand that it was an honest mistake and we
Let me-
cease and desist.
So let me finish on that. I don't doubt that it was an honest mistake. However, I know for a fact that Airbnb, when you sign up a property on Airbnb, they have multiple warnings when you're signing up that says to make sure that your property is, that this kind of rental is allowed in your, they have that.
Right,
You
we
have-
did,
it's
we
a
did.
home.
Yeah, we're zoned exactly the same as next door.
But did you check with your local city government the way Airbnb tells you to do?
Of course, absolutely, yeah,
Who did
that's
you
what I'm
check?
saying.
Who did you check with at the city?
Online, the zoning. My husband's a state inspector. And that's why
But
we
did you
did
reach-
it. We thought it was, we're
No.
the
Did you
same.
reach out to the city to ensure that that kind of behavior was allowed, is what I'm asking, because that's what Airbnb recommends.
Yeah, we just looked online.
We just looked online at the zoning map, and our two properties right next door to the other unit that does weekly rentals is zoned RP. We're zoned RP at the house, and then we're zoned RP at 500.
Yeah, so that's why.
So
Well,
we
I
didn't.
don't want to beat a dead horse.
I'm sorry, yeah.
I don't want to be a dead horse. I made my point, and the city had nothing further.
Yeah, we're not trying to contradict anything. We're just saying that's
why.
where we came to our conclusion. And we apologize.
It'll never happen again.
Does the city have anything further?
Nothing further, Your Honor.
Okay. In the past, I have said this. The city licenses many things throughout the city, and when fact is, in most cities, there are licenses, and the way one goes about doing that is to check with the city. That's the one most knowledgeable, because the code itself does prohibit, well, it allows short-term rentals in only one small area. And my understanding, this is not within that area, so it is prohibited by city code. The fact that somebody is doing something next door illegally doesn't necessarily absolve you from the fact that you're not doing what I would consider to be due diligence if you're going into essentially what amounts to a business operation and checking, because the city licenses most everything that relates to cities. It licenses long-term rentals, it licenses even the short-term rentals that are in the areas have a,
Yeah, the motels and hotels.
yeah. So, I mean, the fact that you sort of skip the city in your review of what was permissible and impermissible was unfortunately your fault. And I've heard, and so I just try to treat everybody the same way. And so I have, as I said earlier, the city had initially, when I first started doing this, wanted to cite everyone for $15,000. And I had brought it down and brought it down and brought it down. But at some point, I have to treat likes like likes. Folks who fall in this category are going to fall within the $1,000 unless there is some extremely extenuating factors. And I'm not hearing any other than the fact that, well, other people were doing it, and we're similar to what those people who are doing it illegally are, so we can do it too. Because if my understanding is correct, the people next door or whatever who you say are using short-term rentals, they're not properly zoned for it either. So just because somebody's doing something that is not permissible by law doesn't excuse the fact that other people are. So therefore, with respect to this matter, I am going to do as the city has requested, which would be in line with what I consider to be fair to all of the people who appear before these hearings. So therefore, in case I hereby find the respondents Daniel W. and Phipps and Kimberly A. Phipps in case number RTL 012601 as the owners of the property at 500 Silver Beach Avenue to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time that the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes, and if the property has subsequently been brought into compliance on, what was it?
October 21st, 2025.
October 21st, 2025, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. And as was said earlier, this is a fine that is levied against the property. It accrues interest like any other kind of lien, and it's good for how many years?
20 years.
20 years. And my understanding is the city is not in a great haste to collect on these things because it would probably cost them more than $1,000 to collect the $1,000. But at some point, if the property is sold, it comes out of the closing proceeds and goes to the city or some other, there may be other situations where that occurs, but nobody, I think, is going to be knocking on your door tomorrow demanding $1,000, but that's just the way it is. Okay.
Is there any way that we can make payments? We're financially strapped.
What you just said is
Yeah.
not, you don't have to be worried about that. They're not going to be knocking down your door.
There will be interest that accrues on it. And so if there was payments, if let's say you wanted to pay it off 5 years from now, it'd probably be more than $1,000 and be.
So in terms of payments, I'm not really sure how that works. Do you know?
If you contact our office, in some cases, things can be worked out. Just contact us afterwards and tell us what you guys are thinking about, and we'll see what we can work out.
Okay.
Thanks, Kevin.
Thank you.
Okay. Is there anything further? Then we're moving on to case number 3. RTL 012602, Hector Luis Rodriguez Jr., cite for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 908 Jeffrey Street.
Good morning.
Good morning. Mr. Rodriguez?
Yes, sir.
If you could be sworn in.
If you can state your name for me.
Hector Luis Rodriguez.
All right, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed October 29, 2025, and they were notified the same day. The property stopped actively advertising as of December 23, 2025. The daily posted rate was $348. The advertisement displayed one review. The check-in, check-out time were shown as 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $15,000.
Did you say 15,000?
Yes, the total duration was from October 29th to December 23rd.
Okay. Mr. Yates? Mr. Rodriguez, I'm sorry.
What, our short-term rental.
Oh, that's right. Ms. Diaz, do you have anything to add?
Were you present when I made my speech? Or, no? Okay.
Oh, you said here?
Yes.
Yes,
Yes,
okay.
okay.
Yeah,
Would
I hear
you
everything.
like me to reread it, or do you mind if he just puts it on to the record for your case?
Oh, you can put it on.
Okay. The city motion that the city's position be entered into the record as evidence for this case.
Okay.
Not evidence, as a city's position.
Mr. Rodriguez has heard that he has stated he heard the city's position on why these violations should be considered as irreparable and irreversible, and that he is willing to have that presentation as made by the city attorney, Ms. Diaz, originally in case number 1, RTLO 12603, incorporated into the record of this proceeding. And is there anything further from the city?
No, Your Honor.
Okay, then, Mr. Rodriguez.
Yes, thank you for giving me the opportunity to speak about this. I know when I got my first notice of the rental situation in my property, I make contact with all the people that I have booked further after the November 1st, and I cancel all my reservations. And in the process, I have to keep my my Airbnb open because there's a fees that I have to pay people that has been booked to make sure that they find another accommodation in another places. So that's the reason I keep open my Airbnb till December, because there was a lot of people on 26 that I have to pay back some fees so they can look for another place. After that, I blocked all my dates. I didn't have any more red booking after that first notice. And actually, I closed the Airbnb account, and I'm putting my house for sales because I don't have anything any further to keep the house in my property or own the property of the situation of the Airbnb and not rentals. So that's the only thing that I can say. I'm not disputing the notice of the Airbnb, but if I'm asking you if you can reconsider it, the $15,000 and bring it down to $1,000, I'll be more appreciated.
Mr. Rodriguez, simple question.
Yes.
You received a citation.
Yes.
Did you contact Mr. Yates and say, I've got this problem? I think...
No, I did not. But I contact the city, and I make sure that the property was in the city limits. If I was something I can do or get a permit or anything like that, and I got response from the city, and that's when I stopped before, but I was just making sure that I got the right information, so I did that.
Okay. What I'm hearing is that this is you're arguing what I call a mitigating factor against, and usually when someone is looking for the city to, or whatever enforcement agency to be, because I think the violation says you can be fined up to $15,000.
Yes, sir.
Okay, and it's a significant fine. You contact the inspector and say, look, I've got this problem. And my suspicion is that Mr. Yates could then use that as a mitigating factor. Instead, what I'm left with is, as he is probably left with, the fact that you've been told that you need to shut this down, and you need to shut it down immediately, and it stays open for, almost 2 months. And I have had many situations where people have in fact done that and continue to rent it out because they had no intent of ever complying with the city ordinance.
I understand that, but I'm not saying that I did not contact Mr. Hayes, not because on purpose. It's because I didn't have the knowledge or information to make sure that I was doing something right. And the reason that I had my house on Airbnb, it was not because I was renting it. It's because I have already booked people from the 26th.
Well, I understand
and I
that.
have to keep the Airbnb open so I can pay them through the Airbnb. I didn't want to rent the property because I knew there was a notice of cease and desist.
I understand that, but at that point, you should be contacting Mr. Yates and saying, because what he sees is that the property remains available for booking.
Yes.
And he is unaware, I expect, that you have said, I've noticed that Mr. Yates has been able to work with people.
Yeah.
And the problem is, all he sees is somebody who is basically thumbing his nose at it because he doesn't know you're keeping it open so that you can notify.
Yeah. I apologize for that because I didn't.
Yeah.
On my mistake. Not contact the city for that.
To clarify our methods at the city specifically, the moment you contact me and we start the discussion of I'm attempting to take this down, I give you credit from that point forward as long as you are cooperating.
Yeah.
I do not go and say, oh, you're not technologically advanced. It took you 24 hours, so you don't get that credit. No. The minute you start working with the city to take it down, that's when your date is. And specifically this first instance in this December 23rd date is not actually necessarily the closing date. That's the date that I started my Christmas vacation. So when I came back from it, it was down. So he gets the credit from the last day I was there, not even necessarily the day that it actually came down. So we do work to give everybody all the
But I
credit
didn't know
and
that he was
mitigating
there.
circumstances we can.
Yeah, I apologize for that. Sorry.
I have a couple questions. So, I'm familiar with the way Airbnb works. Why couldn't you unlist it, in your opinion? Did you call Airbnb?
Yeah, I contact Airbnb.
And they told you
And
that
they
you
told me
couldn't-
that they have to pay the fines, the fees to everybody that I book on the 26th.
That wasn't my question. My question
sorry.
was,
Yeah.
did Airbnb tell you you were unable to unlist the
Yeah, unlisted, and I have to block all the days. They told me block all the days so you don't get any more rentals. Contact all the booking that you have for the 26th. Make sure they understand what you're dealing with and what is the situation. Even I didn't print anything from the Airbnb, but I was contact everybody about the citation that I got from the city, what was going on.
So-
I explained everybody what was the situation, and that's why the reason I didn't
So I
bring it
want
down.
to just remind you before I ask my question again. You are under oath.
Yes.
I know this is not a criminal court.
No, I know.
But,
I understand.
But it carries the same weight about you being under oath. So I'm going to ask you again. Airbnb, your testimony today that Airbnb told you that you were unable to remove
Unlisted, yes.
Unlisted.
Yes, and keep the.
Do you have that in some kind of writing?
No, it was a phone call.
Okay.
Yeah.
If we were to call Airbnb, they would verify that. They
maybe yes.
Do they record all conversations?
Yeah.
Okay.
I contact them and they told us since you have all the bookings, you have to keep
Yeah.
block all the dates
In
and
that
send
case,
it back.
contact Airbnb,
Mm-hmm.
ask them to give you any records or recording where they told you not to unlist it, and we're willing to continue this
Yeah.
case.
Yeah, just because it's such a large fine, sir, if you have evidence to say that they forced you to keep it up, we would want that.
Yeah.
Let me say this.
Yeah.
I don't enjoy levying large fines. And if there are good reasons, verifiable reasons to reduce the amount or whatever, then I want to hear it.
Yeah.
Okay? But, I've also noticed that sometimes people come forward and they hear a good story from somebody before, and suddenly everybody has the same excuse. And I know some of them are not telling the truth. So I need, there's, what was that called? Trust but verify. Mm-hmm. And I like that. And if there is something out there that supports what you're saying, I am more than happy to hear it.
Yes.
I will give you credit for, city, I expect, would probably come forward and say, we've got something here and we can reduce it. And I'm more than happy to do that. I don't want to levy big fines because I know a lot of people are strapped for money and all of that. But the same token, I want to be sure I'm not opening Pandora's box and I've got everybody saying the same thing and I can't.
I understand, sir, but this is my first house at Airbnb, be honest. I never have encountered this situation before. So for me, see that I got a big fine, and I'll be honest, I didn't know anything about the whole Daytona City situation of the rentals and anything like that. And it's my mistake, big mistake.
Let me say that, and this is something I have been saying, it's been going on for years. You're not alone, okay? Somehow people believe that they can essentially open up a business, what amounts to a business, and not find out from the city whether or not there are certain requirements that need to be met. Whether it's long-term rentals, short-term rentals, all of these types of things.
Yes.
You know, their business tax licenses and all of these other things. And it's easy money if you collect it and leave out the people who might be necessary to either charge you a fee, a license tax, or require inspections or any of that. It's all upside. Well, that's not the way things work anymore. Government tends to license almost everything or regulate it in some fashion.
Yeah.
And so, you know, it surprises me because I've been doing this now for 7 or 8 years, and I still hear folks like you come forward and say, well, I have this nice profitable way of making money, and it's pure profit, other than the amount you give to Airbnb and anybody who you pay out who like cleans the house or anything. And the world just doesn't work that. There's no taxes and no anything.
Actually, I called the city permits requesting, or I applied for a permit for that property. There's emails. Actually, there's an application of the city thinking that if I can get that permit,
So that
I can continue.
That permit was for long-term rentals.
Yeah,
correct?
I got a call from the lady. It says
On the application and the communications, I believe that it says long-term, right? Kevin, do you know?
Yes, the long-term does
So
specifically
it does
state.
tell you, that makes it even worse.
I know.
Because it tells you that there's a difference.
Yeah,
between
that's what I
long-term.
applied, and then I called the city, and I found out there was
6 months and a day minimum.
1 day.
Yeah.
And then I said, okay, I
So
understand.
we're going to give you time at the next hearing. Just bring those records to us. Kevin is one of the fairest code inspectors that I know. However, I still want on the record to be included that I have objections to the fact that you never contacted him.
No,
And so that was-
it's my mistake. I didn't contact him.
Even if Airbnb told you to
Yeah,
not list
I
it.
understand that, and I apologize for that. And to be honest, it was an honest mistake not calling him. Shouldn't do that from the beginning, but I thought it was contact everybody, making sure block the dates, pay the fine, the fees that I had to pay to everybody to make accommodations in other places will resolve the problem.
I hear you, and we're going to continue this till, what is our next hearing date?
February 24th.
February.
Yeah, the city has nothing further
The city has nothing further?
for
Good.
this case.
Okay. So, sir, please get with them
Yeah,
and try your best to provide them with some verifiable things so that they can come forward, because I don't like levying big fines if there's a good reason why I don't have to, okay? But I try to treat everybody fairly, and if people don't come forward with the right kinds of information that assure me of or substantiate the stories I hear, then I'm kind of left, everybody will be saying the same thing, and I'm left with a situation where I think that very well could be the wool is being pulled over my eyes, and I don't want to have that happen. So since you may have information that the city can use to reduce the amount of the fine or whatever, please get with them and try and work it out. And so therefore, in case number 3, RTL 012602, the respondent being Hector Luis Rodriguez Jr. for property at 908 Jeffrey Street, I hereby order that this case be continued until February 24th, 2027. 26.
If you get the records, please give them to him
Yes,
beforehand.
yes, definitely yes. I will contact.
And if Airbnb is emailing you something, have them email me too, not from you, from them.
From them?
Yeah.
Okay, yeah. We have, you got your email on?
Yeah, it's on all your citations and all that,
Citations.
and, see, because I forgot my cards today. A little embarrassing.
There you go. Okay, Kevin.
Thank you, sir.
All right, thank you. Thank you.
Okay. Thank you. Case number 4, RTL 012604, Brian Alexander Stretch, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 110 South Peninsula Drive. Is Mr. Stretch present? Sir, if you could come forward and state your name and be sworn.
Hello, Brian Stretch.
Okay, if you can raise your right hand for me. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Mr. Yates.
All right, the case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 7th, 2025, and they were notified the same day. The property stopped actively advertising the same day, November 7th, 2025. The daily posted rate was $320. It displayed no reviews. The check-in, check-out time were shown as 2 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Diaz, do you have anything to add?
Yes. Were you present and paying attention when I gave my speech the first 2 times?
Yes.
Would you like me to repeat it for the record, or are you okay if he just enters it in?
You don't need to repeat.
Thank you. The city motions to enter the city's position about why these violations are irreparable and irreversible into the record.
Okay. Therefore, I am going to order that find the city's position that these violations are irreparable and irreversible be incorporated into this proceeding. Mr. Hector Rodriguez Jr. has agreed. Oh, I'm sorry. Mr. Stretch
Yes.
has agreed that these arguments made by the city are to be incorporated into the record of the proceeding, with the caveat, of course, that if you find that these things are, if you have objections to them, you can state your objections. You're just allowing them to be incorporated into the record, so she doesn't have to repeat them.
I understand.
Okay? Mr. Stretch.
Yes. So this property was listed on VRBO as a long-term rental. Specifically, you needed to rent it for 190 days. I saw the report come in, and I did take it down right away just because I wanted to make sure I was crossing all my T's and dotting all my I's. But from my understanding, I can have a long-term rental on those platforms.
Can you pull up the booking?
I think you had a picture of it on there. Yep.
Yeah,
So
it's-
I reached out to support, and specifically with this one, I mean, I can read through the transcript, but he had mentioned, or she, no, definitely a he, asked if the link was from a foreign site, and I see that is from a New Zealand site, which he specifically says, was it from a foreign site, Wales or New Zealand? I said, yes, I think it was New Zealand. He said, there's a known issue with there's a known issue in the system with programs like Granicus, Civic Plus, and Acela that have been generating links to listings that are not advertised as available. I think that's what happened here.
That email, did you send that to him beforehand?
I did not know.
Okay, who's that from?
Alejandro at VRBO.
Do you have extra copies?
I do, yes.
Can you have Alejandro send that exact verbiage from his email to Kevin?
It's doubtful that I'll get Alejandro again, but
Or someone, can you, just so we can
Sure.
verify the, are you wanting to continue this?
so I do have a permit for long-term rental.
Okay,
And quite honestly, I'm not using, I mean, I guess it doesn't matter, VRBO to actually generate a rental. It's more to make backlinks complicated, but you want to copy this?
Oh, absolutely.
Is what I'm hearing is you tried to advertise for a long-term rental, and some entity on the internet grabbed it and made it sound like it's short-term rental?
I think, does the city use a program to find?
I was going to say the problem is that we don't, and I actually found that off their site.
Why New Zealand? Why the New Zealand link?
Oh, they show both, and I also use a variety of different VPNs because when you access their sites regularly, they know something's up with that and they stop showing you new listings. So you actually have to access it from a variety. But no, we use no automated systems. None of the things he mentioned were used in the finding of this. It's 100% Google, regular. So that what he just said would not apply in this case.
Well, if I understand your argument, it was some entity out there saw this on VRBO and then moved it to their site improperly?
No. So it's listed as a long-term rental, specifically 190
Correct.
days.
That's what you said.
Yeah. In speaking with their rep, they said that if you're using some kind of aggregating program, I don't know what those things are.
No.
Let me cut this short real quick. I don't profess to be knowledgeable about the mechanics of how this stuff is done on the internet. Okay, that's a, and I want to hear, the facts as they were, and it sounds like you may be ultimately in agreement, but if I understand what Ms. Diaz was saying, you would like to have some verification, again, the trust but verify. So I think the proper way of handling this might be to continue this case to February 24th. And if you can, satisfy the city, and then we can deal with it that way.
Before we continue, I just want to make a couple points. When you get all those information, send it to Kevin. I'll give you my card. But he gave me some papers I wanted to enter into the record. In my hand, I have a license for long-term rental, which was issued on January 13th, 2026, which I would like to note was after he received the notification that he was in violation. So he did not have this at the time, so he would have still been in violation of our long-term rental.
I think.
And then he gave me an email. Let me just finish reading what I have in front of me. Then I have an email from VRB, which we need to authenticate, which he will work with us to do. And then I have a screenshot of the property, which we're moving into evidence.
I hear the respondent has some arguments he would like. I think it would be best if you all discuss this, and it sounds like you could ultimately be on the same page, but it would be better for you all to go through, and if the city needs additional documentation or what have you, then you all can do that, and then on the 24th, hopefully we can bring this to a close.
So, just so I'm clear on this, I get them to send you an email, and that will satisfy?
No, we still have a hearing unless you're notified otherwise.
So I got to come back? Can we settle this today?
You can go via Zoom, but we can't settle it today until we authenticate the email. We have had people make, with AI now, anything could be made up. Not that we don't trust you, if we were in a court of law and like a judge wouldn't accept it, it would need to be authenticated. So that's what we need to do. You can appear via Zoom if you prefer to not come back in person, but just procedural, we have to have another hearing to close it out, if that's all right.
Second, as far as long-term rental, my understanding is you need to get this within 60 days of signing the lease. Is that correct?
Yes.
Okay, so, I mean, you had mentioned that I was not in violation, but didn't rent it at all and got this
I'll
true.
correct myself. He didn't have this at the time that he.
Yeah, again, we're getting into the mud, so to speak, of all of this. And I think you all could all ultimately be on the same page, in which case I'm not sitting here hearing all of this stuff that's going on. And so I think the best thing right now is to continue it to the 24th. Now, if it's a long-term rental, it doesn't even belong here because it's no longer an irreparable or irreversible matter. So that changes everything.
Yeah.
And that's what I want to do. I'm going to continue this case until February 24th.
In the interim, can it be listed on there? And I'm fine to reactivate it?
Get with
seeing as
Mr.
it's-
Yates. You've
okay.
got a license, right, for
Yes.
long-term rental?
Correct.
Okay,
so-
and here is the booking from the New Zealand site. It's not New Zealand. So we do have a US-based, sorry.
Work it all out. That's.
We'll just gather
Okay.
more, I think.
Yeah, sorry.
So why don't we, what I'm going to do is continue this to February 24th. And then all of these details you can work out rather than me sitting here for the next half hour while you argue over this piece of paper, that piece of paper, and maybe Mr. Stretch has some other things that come up during this that he says, well, I can provide you with this, and he doesn't have it, so you all can work this out. And if there's still disagreement or what have you, then that can be argued on the 24th. Otherwise, if it turns out that he has, in fact, basically a long-term rental that ended up in a short-term violation, which it shouldn't be, then
We would
case,
request to dismiss, yeah.
yeah. So,
If I sent you that, never mind. I got it.
Contact me
we still have
afterwards,
to-
we'll go through everything
Okay.
and we'll get it right.
Got it.
right. Case number 4, RTL 012604, respondent being Brian Alexander Stretch for property at 110 South Peninsula Drive is hereby continued until February 24th, 2026. Thank you, sir.
Perfect. Thank you.
Okay, we have one more case. Case number 5, RTL 10-2546 HCS Holdings, Inc., cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 707 Harvey Avenue. And this was continued from last month. It's continued from October 28, 2025.
Yes. So before Mr. Yates goes procedurally, I just wanted to note that for due process, he was properly given notice about this hearing. He was, for the first hearing, he was properly served via certified mail. He showed up in person at that hearing. He was given notice of today's hearing in person. So his presence here, his absence today doesn't violate any due process.
Okay, my recollection of that hearing was that his argument was that the advertisement for his property had been placed online prior to his taking title to the property, and that he chose to take no steps to take the advertisement down.
We've had no contact since the last hearing. No information has been provided, so I would simply say that this case is before you was a zoning violation. This case was field generated. The property is zoned RP. Other accommodations nor in short-term rentals are not permitted in this zoning district. The violation was first observed September 18th, 2025, and they were notified the same day. The property stopped actively advertising as of September 19th, 2025. The daily posted rate was $197. The advertisement displayed one review. The check-in, check-out time were 3 p.m. and 10 a.m. And due to these actions, of the owner. They are irreparable and irreversible, and we request a one-time fine of $1,000.
Okay. The dates in all of this are important for me. Because again, my recollection of his argument was that he's trying to say he has no obligation to take down an advertisement that was posted by a previous owner that remained online.
You absolutely do, though.
Well, I understand the city's argument, but his argument though was he claims he doesn't. Do we know when he took? Okay, let's go through those dates again, if you mind, Mr. Yates.
September 18th, 2025. He's notified. He takes it down September 19th, 2025.
Okay. When did he take title to this property? Do we know?
I don't have anything here in the record that would clarify that. See. I don't have the property appraiser's report or anything. Nope. Oh, me. Sorry.
Lena, do you have the minutes from the last meeting?
I do.
I just want to be sure about my recollection of what transpired.
And then also I have the deed that states June 11th of 2025.
Line 18.
So I have the warranty deed
Okay.
of when he would have taken, it says June 11th of 2025.
Okay.
Yeah. Yeah, the next step.
Okay, I'm going to want this to be entered as an exhibit. I'd like to show it to the city.
I don't need to split. City has no objection.
I mean, that's, the city had stated that of this information, but I'd like to see the deed itself
Yeah.
to be entered into the record. Now, essentially what we have, if I understand correctly, we have what amounts to a 3-month gap between the time that he took title to the property and the time that the advertisement was taken down. So he did comply with what Mr. Yates asked of him.
Well, right, but to clarify on that, here we do have a review from August 2025, which means while he had ownership, someone stayed. So it would be impossible for it not to be
And
his.
and Airbnb's review have to be within, I think, a 2-week period.
Yeah,
So-
here we go, August 2025. Sorry.
Which,
Sorry, I keep switching on you. So clearly, he was in control of the house when that review happened.
I see 8/10.
August
Okay.
2025. So, pretty clear he was in control of the house.
Okay.
which implies he,
That's all of this is contrary to what I had heard at that hearing from him. The minutes of that meeting, as I recall, reflected that he stated that the advertisement had been posted by someone else.
apologies, I didn't mean to interrupt while you were talking.
And am I correct in that?
I mean, he did say things like that with no evidence or supporting documentation.
Well, I'm all we have is his testimony from that hearing. Okay, he offered nothing.
Correct.
But he stated that the posting had been made by someone else. And at that time, I was unaware that the fact that the posting was made after he had taken on Airbnb, after he had taken possession of the property. Now, the other question, though, is, was that a posting of a stay that occurred while he was in possession of the property, or was it somebody who 2 months later decided they wanted to post something?
Airbnb doesn't allow guests to post reviews past a 2-week period after they stayed.
And it says stayed 2 nights in August 2025. It tells you when the stay was. And so he bought the property in June. I called him in September, and he has a verified stay in August.
So
Okay.
he, and again, this evidence shows that he lied under oath.
Yeah.
Which I think $1,000 after such a grave violation is more than fair, you know.
I'm bothered by the fact that I left that hearing believing, from what he stated under oath, that this was a problem that had occurred with a previous owner. And in fact, what I'm hearing now in the review that was posted shows that while he was the owner, people were staying there. And the city is asking for, what, $1,000 fine?
And I mean, we have no objection to anyone raising it. It's simply that's in line with how quickly he took it down.
Okay. If he was someone, I can't really fine somebody for being, I hate to say it, untruthful. Because that's what I'm seeing right now is he's saying that it occurred under a previous owner, and it's not his problem. He did the right thing, and we had other people who have done in similar situation, and the fine they would have received would have been $1,000. And so,
I hate to interrupt, but other people, every other member that came here today apologized and did not lie under oath. He lied under oath.
I don't feel inclined. I understand what it is. I think there could be other remedies, but I am simply going to treat him as I do with other people the same way. Although the record reflects that what he stated may not be in accord with what really transpired.
Unfortunately, I think you might be seeing him again. I've been keeping an eye on that property.
Well, okay. So, all I can say at this point is that I'm going to hold him in violation, and I'm going to impose a $1,000 fine. And he was notified of this hearing. So therefore, with respect to case number 5, I hereby find the respondent, HCS Holdings, Inc., in case number RTL 102546 as the owner of the property at 707 Harvey Avenue to have been in non-compliance of Article 4, Section 4.1A and Article 5, Section 5.2.A.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. And as such, violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time that the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes. Property has subsequently been brought into compliance on September 19th, 2025, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. I will add to that the respondent was notified of this hearing. He was present at the hearing and was verbally notified that it was continued to today's date. As my understanding was, he sent a notice as well.
Yes.
He was sent a notice, and that there has been no. So that takes care of that. We now move on to miscellaneous business. Is there any miscellaneous business that needs to be taken care of?
No, there is not.
Therefore, it being 10:27, I hereby call this meeting of the special magistrate proceeding to be in adjournment.